From the main list, item number 1.
Yes. Volume. Yes. What is the matter about, Mr. Advocate? Oh, so the Supreme Court stay still operates. Very good. Since the stay granted by the Supreme Court on January 30, 2023 still operates, come and let the matter appear 8 weeks since, full stop, the parties will have liberty to mention for earlier hearing if the Supreme Court case is concluded by then.
Your Lordship, 18 July, so any date after 18 July.
18 July, so we will, very well, 12 weeks.
May I please order? The next date is fixed on 18 July. We have the
July,
copy.
that's what he said. We've kept it after 12 weeks.
Clear.
Item number 2.
May it please, Your Lordship.
Yes, sir.
Lordship, I'll have to start my submission with an apology.
What is the apology?
The apology, Lordship, was that on 22nd March, I had made a submission, Your Lordship, that we framed the rules.
Yes.
15 December 2022. So after the order of 22nd March, Your Lordship, we received a formal communication on 23rd from the department saying that it had been notified, the same rules has been notified. In Gazette notification came on 29th December itself, Your Lordship.
29th of?
December. I had made a submission, Your Lordship, regarding that the Gazette notification is yet to come.
Very well. So
next day.
What do the rules provide?
Lordship, the rules provide, we have categorized.
Do you have a copy of the rules, Dr. Manikar?
No.
Do the rules also provide for quantum?
Lordship, yes.
How much is it?
Lordship, yes.
Due to quarrel, 7.5 lakh, my lord.
Lordship,
Negligence of duty, 5 lakh. Torture, 7.5 lakh. Suicide, 5 lakhs.
No.
Lordship, kindly allow me to explain. We were expecting, Lordship, this bound to be some amount of agreement, disagreement. Lordship, this was based on a model prepared by Haryana. And that too, a full bench, full commission of National Human Rights Commission.
That does not affect us. This is not appropriate. I think it has to be increased because we'll go by the COVID figures, which the Supreme Court granted. How much was that? 15 was it? What was the compensation for COVID death?
No, my lord, I was just trying to Google search this morning, my lord.
Yes.
The amount was less, my lord.
The COVID death was less?
My lord.
We were under the impression COVID death was more.
My lord, in one of the cases, this honorable court awarded 15 lakh rupees, my lord.
For COVID?
By judicial order. No, my lord, it was a torture, death.
Torture.
Lordship, if
so let us accept this. Then if anyone comes up individually
absolutely,
to say that,
absolutely.
This is not adequate, then we'll take it up from there.
Absolutely.
And we'll say that, it appears inadequate to us and should be enhanced somewhat. And we'd also say that, at least a 25% enhancement would be in order. We'll express that view, but that will not be binding on the state. If the state wants to follow this, they can. When it comes to quantification, we can do it later.
Absolutely, Lordship.
But today, do we have all the figures of these 5 categories?
My lord, more or less, I've tabulated, my lord. There are 49 deaths, and I've indicated which ones are because of suicide, my lord.
So, are we agreed on that, Mr. Khan?
Lordship, I may suggest, since this quantification was not in place, and we have got a number of cases which has to be dealt with individually.
No. He has categorized.
Lordship, yes.
Now, out of that, is for you to accept the categories or not?
Absolutely, Lordship.
Now, if you accept the categories, then our work is done. For individual cases, maybe out of 49, maybe 20 you agree.
Absolutely, Lordship.
And 29 you don't agree. Those 29 we'll have to put them in the appropriate category by adjudication.
Lordship.
And then these figures will apply, and we will request you to enhance it. But at any rate, what we are going to do is we are going to provide for interest from the date of death.
Well,
But
Because that would be the appropriate thing. We are going to provide for interest from the date of death.
Lordship, a small suggestion. What Mr. Muzika has done, Lordship, if he can forward us officially, and then this scheme, and then state will take care and consider. Lordship, can you give us at least 2 months or 2.5 months time? We'll consider.
No, not that long, not that long. We want to finish this off.
No, Lordship, the state will consider.
Yes.
If the compensation is paid within reasonable time, Lordship, considering the parameters given by the amicus. And if there's any dispute on that, Lordship, we'll take care of that. We'll try to give the compensation as per the scheme, and rightly said, Lordship, in case there is any other further dispute. So, Lordship, I'll just give a notification of 2nd May.
2nd May.
We just got the notice, Lordship.
There's a further notification.
Further notification, Lordship, in case of the findings of quantum are inconclusive, Lordship, the notification says the quantum of compensation shall be determined by the competent court. So we are aware of it, Your Lordship, that Lordship, state also is aware in case there could be some difference of opinion on the quantum. So we'll finish the entire exercise, Your Lordship. Give us some reasonable time.
Your notification is suicidal for you.
But Lordship, we have to come clean.
No, this notification is suicidal for you. This notification should have been that the quantum of compensation according to the state will be paid at the first instance, and if categorization is done in any other thing, the balance will be paid pursuant to order of court. Over here, you've left it open for quantification.
Lordship is correct. Lordship is correct. Because Lordship, we were aware that maybe we'll have to meet a difficult situation. The scheme of compensation could not be adequate. But in any case, Your Lordship, we will overcome the first hurdle, Your Lordship.
But at least we are at 49. We are the figure is at 49.
Lordship.
49 deaths, my lord. Some may be natural deaths in this matter.
Very well. There are 49 deaths.
My lord.
Lordship is.
And deaths in custody, 49 since 2012.
2012.
Very well. Mr. Khan, Learned Additional Advocate General, begins with an apology since the submission recorded in the previous order of March 22, 2023 was inaccurate. Full stop. The order dated paragraph, the order dated March 22, 2023 recorded the state submission to the effect that it was in the process of framing rules and guidelines pertaining to compensation for cases of death in custody modeled on the rules adopted by Haryana as approved by the NHRC. Full stop. It, however, appears that by notification of December 15, 2022, the state had already formulated a scheme for payment of compensation to the bereaved families of persons who had died either in police or judicial custody, and also prisoners in the correctional homes in the state. Full stop. A further notification in continuation of the previous notification of December 15, 2022 has been published on May 2, 2023. Full stop. The original notification of December 2022 provides for compensation to 5 classes of persons who suffer custodial death, persons dying due to quarrel among prisoners, person dying due to negligence by prison officials, person dying due to negligence by medical or paramedical officers, person dying due to torture or upon being beaten up by the police or prison staff, and person committing suicide while in such custody. Full stop. The notification also, the original notification also provides that no compensation would be payable in case of natural death due to illness and where state officials may not be responsible for such death. Full stop. Compensation would also not be admissible if the death occurs during escape or due to any natural disaster or calamity or any pandemic. Full stop. Paragraph. In cases of death due to quarrel among inmates, quarrel among prisoners that I said, no, it should be inmates. The first one, inmates, and death due to torture or being beaten up by the police or prison staff, the compensation provided by the notification is rupees 7.5 lakh. Full stop. In the 3 other cases, the quantum of compensation is rupees 5 lakh. Full stop. Paragraph. The recent notification of May 2, 2023 provides that in cases where claims and counterclaims arise in connection with death in custody not due to natural causes or suicides, and where findings are inconclusive, the quantum of compensation shall be determined by a competent court. Full stop. Paragraph. As far as the present matter is concerned, the same deals with custodial deaths in the state since the year 2012. full stop. The matter has continued for quite some time and, comma, at last, comma, the state accepts that there have been 49 instances of death in custody since 2012 till date, full stop. The figure has been vetted and verified by Dr. Mozika, comma, amicus curiae appointed in the matter, full stop. Paragraph details as to the possible cause of death in each case have been furnished by the state, and the court is grateful to Dr. Mozika for going through the same and categorizing the cause of death in each case, full stop. Dr. Mozika is requested to formally make over a copy of the details or report in such regard under cover of a letter to learned advocate for the state, full stop. Such exercise should be completed in course of this week, full stop. Paragraph. The state submits that to the extent the cause of death indicated in Dr. Mozika's report is found to be appropriate, comma, there would be no questions asked, and the quantum of compensation as indicated by the notification of December 2022 would be paid, full stop. However, comma, in certain cases, comma, where the death may have been due to natural causes or due to suicide,
Suicide is covered, my lord. Suicide is covered by the notification, my lord.
or due to suicide or lesser causes than torture or as a result of a fight breaking out among inmates, comma, the state will present its own version for the adjudication to be conducted by the court in respect of the individual cases where there is disagreement between the report and the state's findings, full stop. Paragraph. This whittles down the scope of the proceedings to only the cases where the state may not agree with the cause of death as indicated in Dr. Mozika's report, full stop. There appears, comma, therefore, to be light at the end of the tunnel. Paragraph. As far as the quantum of compensation is concerned, comma, the court perceives the amounts indicated in the notification of December 2022 to be slightly lower than the figures that had been informally indicated in course of previous hearings, full stop. The state may do well to increase the quantum by about 25% or, comma, at the very least, comma, make a distinction based on the age of the person dying in custody. full stop. At any rate, comma, it is made clear to the state that the quantum of compensation as indicated or as may be enhanced in accordance with law will fall due immediately upon the death of the person and, comma, as such, comma, for any delayed payment, comma, whether willful or otherwise, comma, interest would accrue. Full stop. Paragraph, since the state seeks sufficient time to consider the report prepared by Dr. Modika, comma, let the matter appear 6 weeks hence. Full stop. Even if you don't increase the quantum generally, if you can make a distinction between, people before 40 and after 40.
Absolutely.
Just as in motor accident claim.
Absolutely logical, correct.
The life expectancy has a thing nexus with quantum of compensation. Otherwise, this would appear to be somewhat arbitrary.
Absolutely.
You can make that kind of distinction and make it 25% more for people who are aged less than, 40 or something like that. There has to be reasonableness about the thing. 78-year-old goes and hangs himself, and 18-year-old is beaten to death.
Difference.
There is a clear
difference
between the two, and it won't be fair to categorize them in the same basket.
Absolutely. What you will consider. Thanks.
Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
May it please, Lordship.
Yes,
Lordship,
sir.
this is a traffic matter, Lordship.
Yes.
Filed for the purpose of easing
Yes.
the traffic congestion in Shillong. And as per the last order, Lordship, your Lordship has directed the state to file an affidavit indicating
Yes.
the steps taken to ease the traffic congestion in the city. So far, nothing has
May
been
please, Your
initiated.
Lordship. Lordship, we have received the status report on the action taken just yesterday evening, Lordship. We are filing it during the course of the day.
Very well. The state is permitted to file its affidavit or report in terms of the previous order of
14.
April 17, 2023, in course of this week. Paragraph, let the matter appear next week.
Obliged, Lordship.
Give a copy to him, please.
Lordship, yes, absolutely.
Fully obliged.
Item number 2.
This is of overloading of vehicles.
Lordship.
Where are we now?
Lordship, there has been slight improvement in that after Lordship has observed in the last order that areas of Peninsula, Shella, Docky, Nongstoin, etc. require further attention. Two aspects fundamentally that were taken up was one, to create awareness of the prescribed weight limits. So in that regard,
Very well. What we are doing is,
Yes.
we are giving the state some leeway. We are giving the state some leeway. We are also asking them to increase the number of checkposts for way bridges or what other was there? Pads,
Yes, instrument
Yes,
of
weight
pads,
pads.
weight pads and
electronic brakes.
because for the first time they have come out with a notification. If you see this report, which indicates 17th April notification, which indicates permissible net weight according to number of axles. So 5-axle trucks are permitted to carry a net weight of up to 35,000 metric of kg. So which is
34 metric.
34 metric ton. So let us see what thing. Pursuant to the order dated March 31, 2023, a report has been filed by the state. Full stop. The report indicates that awareness programs have been conducted among officials and other stakeholders to ensure that overloaded vehicles don't take to the state or national highways in Meghalaya. Full stop. There also appears to be a press release issued on April 17, 2023, indicating the types of vehicles, the axle combination of such vehicles, and the revised permissible net weight for each category. Full stop. The press release, issued under section 194 of the Motor Vehicles Act 1988 also provides for excess load being offloaded immediately upon discovery at the owner's or transporter's cost. Full stop. Paragraph, as observed earlier, the number of weighbridges and checking places should be increased. Indeed, electronic weigh pads as indicated by the state should be introduced at several more places, including places where boulders are carried and roads leading to the land customs stations, full stop. Paragraph, it is also hoped that the 23 weighbridges that the state promised to make functional would be in place before the matter appears next. In addition, way pads that, according to the state, would cost rupees 27 lakh each should also be procured to be used at strategic points, full stop. The matter will appear 6 weeks hence for a further report from the state.
Lordship may consider granting us 8 weeks time so that when we come back next, the compliance
Come back after 6 weeks. Good to see you after every 6 weeks. 8 weeks is too long.
Lordship.
Yes.
High Bearers, madam.
Item number 3.
May I please, Your Lordship?
Yes, madam.
Your Lordship, the conducting council's grandmother expired, Your Lordship, so he has to perform some
Counsel?
ritual. Conducting council for respondent number 1, grandmother has expired and he has to perform some ritual, Your Lordship. So I humbly pray that this matter be taken after 2
What is the matter about, Mr. Khan?
Appeal against an acquittal.
Appeal against?
Acquittal, Your Lordship.
Appeal against acquittal. Since it is submitted that conducting counsel on behalf of, counsel on behalf of the first respondent has recently expired. When did he expire? 3 years back?
Council, my lord.
No, sir, grandmothers.
Since it is submitted that counsel for the first respondent has suffered a bereavement, let the matter appear a fortnight hence.
Much obliged.
I'm okay. Respond number 2. Item number 4.
May I please, Your Lordship? Your Lordship, this is an appeal against the conviction actually under section 326 and 307 of the IPC. Your Lordship.
326, 307.
326
and 307.
What was the grievous hurt caused?
Grievous hurt actually, it is shown that some injury was there actually by sharp weapon.
And what is the sentence?
Sentence was actually for the 326, it is 8 years imprisonment along with fine of rupees 8,000. And for 307, 10 years imprisonment along with fine of rupees 10,000.
307?
Yes, madam.
307 is a very difficult conviction.
Yes, madam.
Yes. Shall we proceed, Mr. Shengupta?
Yes, my lord. Sir, Jishnu will be. Let him start.
All right. Your Lordship, first of all, I would like to actually draw the attention of this Honorable Court on running page number 8, my lord, of the paper book. This is the typed copy of the FIR. From where the incident occurred in the... May I read it?
18th January
2014, man.
2014, and this is Joy PS.
Joy PS.
Yes.
So, here this complaint has been filed by the brother of the victim, my lord. namely complainant Jabir Hussain, son of late Kutubali. It is Lebarkota Part 1, PS Katigara District Kachar. He is from Assam, my lord. So he is stating in the FIR, my lord, I have the honor to state that on 11/1/2014, at about 8:30 p.m., while my brother, namely Muhammad Ajmal Ali Barbuya, going from Calaria towards Dauki border with Tata truck number BR number ML05F 2790, when they reached at 8th mile on NH44, then the driver stopped the vehicle for taking dinner, and my brother sitting inside the truck. Suddenly, the above accused and his associate come forward and demanded money from my brother, but my brother denied their illegal demand. Then the above accused and other attacked by my brother with deadly weapons and stabbing his stomach, chest, head, etc. with intent to murder my brother. As a result of which my brother got grievous injuries on his person. After they committed the crime, the accused persons fled away from the spot immediately. My injured brother shifted to Joy Civil Hospital for treatment by one local mechanic, but doctor of Joy Hospital referred him to Shillong Hospital as the condition is very much serious till today. He is stating, my lord, actually when he is filing this FIR on 18th, he is mentioning hospital as the condition is very much serious till today. My brother is unconscious at Shillong Hospital. It is to mention here that all the family members are engaged for treatment of my brother, so could not submit the FIR at due time. Therefore, I pray your honor may kindly take necessary action against the accused persons as per law. So here, one thing here, two things is to be important here, your honor. He has belatedly filed this FIR on 18/1/2014, my lord. This is a belated FIR. An incident happened on 11/1/2014. And moreover, he has mentioned the vehicle number ML05F2790, in which the incident took place, and condition of his brother, he has stated that he is still unconscious at that point of time. So please, my lord, page number 14. This is the charge sheet. Page number 14.
40.
Yes, no, 14, my lord.
14.
This is the charge sheet filed by the IO, my lord. May I read your motion?
Yes.
Brief facts of the case. The prosecution story of the case is that on 18/1/2014, received written FIR from Sri Jabir Hussain Barbuya at Lebarkota village of Lebarkota village, PS Katigora district, Kachar, Assam, to the effect that on 11/1/2014 at about 8:30 p.m., while his brother Sri Ajmal Ali Barbuya going from Calaria towards Dauki border with Tata truck bearing number ML05F2790, and on reaching 8th mile NH44, the driver stopped the vehicle for taking dinner, and his brother sitting inside the truck. Suddenly Sri Akhlasuddin Chaudhary and his associates came forward and demanded money from his brother, and his brother denied their illegal demand and attacked his brother with deadly weapon and stabbing his stomach, chest, head with intent to murder, and as a result of which he got grievous injuries on his person, and the accused persons fled away the spot after committed. The injured person was shifted to Civil Hospital, Joy. As his condition was serious, he was referred to Shillong, hence the case. During the course of investigation, the complainant as well as some witnesses were thoroughly examined, and also the victim person Sri Ajmal Ali Barbuya, and also visited the place of occurrence, where a rough sketch map was drawn at the spot. The medical report of the victim person was also received from Negrim's Hospital, Shillong, where the victim person has undergone treatment. The main accused person, Sri Akhlasuddin Chaudhary, who was a named accused person in the FIR, was arrested and forwarded to the Honorable Court. while the other co-accused person could not be identified and could not be ascertained their whereabouts, as the arrested person could not confess their name. Hence, a prima facie case under section 386, 307, 326 IPC was found well established against the arrested accused person, Sri Akhlasuddin Chaudhary, under the above sections of law, whom I beg to send him up to stand for a trial in the court of law under the aforesaid sections of law. The witnesses noted in the column 13 will prove the case, who may kindly be summoned by fixing a date of hearing. So, the charge sheet has been filed under section 3 sections, my lord. 386, 307, 326 of the IPC. Now page number 22, my lord. This is the typed copy of the deposition of PW1, my lord. This is one Legaras Sila, my lord. So he is stating in his deposition, I know of the case. As on the incident, I was at home sleeping it was night time, and my home is near the petrol pump, near the PO. I am working as an auto driver and auto rickshaw for commercial plying. On that night, I received a knock on my door from the helper of petrol pump, who came to wake me up, which was around 11 p.m. And this helper, non-tribal, whose name I do not know, requested me to go and see an injured person lying near the petrol pump. I went to the place and saw a person who injured and blood all around the place. So I took the injured person in auto rickshaw and accompanied by the helper. We went and dropped the injured person at Yalong Hospital. On the way to the hospital, I stopped the auto rickshaw at Pramar Traffic Cell. Your Lordship, kindly note this point. Actually, he has reported the matter actually to the Pramar Traffic Cell. One police outpost is there. He has reported the matter when he has taken the victim to the hospital on the same day itself, my lord. And informed the police, and police told me to take the injured to the hospital. On reaching the hospital, the medical treatment was provided, and I remained in the hospital till 3:30 a.m. and then come home. In the cross he has stated, my lord, I do not know the injured person whom I have taken to the hospital. I have taken him to the hospital on humanitarian ground. So he did not point at against anybody, my lord, neither against the accused nor against anybody. He has stated only on humanitarian ground he has taken.
They are post-incident witnesses.
Yes, my lord. Then come to the page
26.
Yes, my lord.
Petrol pump attendant.
Yes, petrol pump attendant. So this witness also more or less
Come to the brother, FIR maker, page 31.
What?
FIR maker, page 31, the brother of the victim.
Victim, yes. This is 31 page. I am the younger brother of the PW4, my lord. I have lost the FIR in this case. During the incident, I was in my village at Silchar. And on 11/1/2014, my sister-in-law, wife of PW4, sent for me, and when I went to her room, saying that my brother has been assaulted and cut and admitted at Joy Hospital. I then called my other brother Ajmal, and decided to come to Joy. My sister-in-law come to know of the incident, as somebody rang her in her mobile phone from Joy, telling her that my brother has been assaulted and cut. I, along with my brother Zakir Hussain, Kusan Hussain, Majmal Hussain, proceeded to Joy and reached Joy at 4 a.m. We inquired from people regarding the location of hospital and went to Civil Hospital Joy, where we saw PW4 with oxygen mask, and the doctors told us to take PW4 to Negrims and referred him. And on that day, we arrived at 12/1/2014. We brought our brother to Negrims Hospital. While on the way to Shillong in an ambulance, the oxygen was removed for a very short while. Please note this point, my lord. He has stated that the oxygen mask has removed for a very short while from my brother. And I asked him who has done this to him. And my brother replied that it was Akhlasuddin Chaudhary. We reached Negrims and my brother was admitted for more than 15 days in the ICU. His brother was there in 15 days in the ICU, my lord. From the day of incident. After a week, when my brother was able to take some food, I come to Joy and lodge the FIR, which is Exhibit 1, and 1 by 1 is my signature. Then, my lord, page number 39. May I read, please? Page 39. Statement of PW 4C Ajmal Ali. This is the victim, my lord. And dated 23/4/2015. I know of the case as I am the victim. I know Akhlasuddin Chaudhary, who is the co-villager of Lebarkuta village, Silchar, where I reside. On 11/1/2014, I was doing business in Ladimbai, and around 8 a.m. I was finishing loading truck in my truck ML052790. So loading started at 8 a.m. Please note it, my lord. The loading started at 8 a.m. morning. And I come to Mukeb village with the truck driven by my driver, whose name I do not remember. Reaching Mukeb village around 8:30 to 9. So this is only half an hour or 1 hour they have run, and then they have stopped in a place, namely Mukeb, your lordship, this village. The driver wanted to have tea, and I told him to go ahead while I sat on the vehicle. But the driver never come to vehicle and return only around 4 p.m. This is very important, your lordship. For whole day, the driver was not here. He has gone somewhere and he returned at 4 p.m., my lord. I asked him where he disappeared, and the driver replied he went for some work. And then we proceeded with the truck, and on reaching NRL petrol pump at 8th mile, we stopped the truck. As the driver said, now checking is going, and we should leave after the check gate people have left. So another excuse he has showed, the driver, he said that some checking is going on there, so after left of these people, he will start. So the driver again left me in the truck saying that he will be coming. So another pretext is there, or another statement is there. The driver has left by saying that he will be coming. I waited till 7:30 to 8 p.m., my lord. And as the driver did not return, I went to have dinner in a shop near the petrol pump. After having dinner, I come back to the truck, and I saw the driver and handyman in the truck, who then said for me to wait in the truck as they are going for dinner. I waited, and as it was cold, I took a blanket and slept in the truck. After half an hour, the doors of the truck was opened, and 2 people were on each side of the door, which mean 4 people altogether. And I saw one of them to be accused, Akhlasuddin Chaudhary. And I asked him why he is there. And the accused stated that he had been after me for 4 years now, and then started stabbing me with a kukri. I then kicked 2 persons, including the accused driver, side of the door, and both of them fell down. Then one was grabbing my neck from the handyman's side of the door, but I managed to throw him out, and in person. In the process, I also fell outside. And that time I realized that my intestine had come out, and I hold it with my hand. The accused then came and hit me on the side of my head with a kukri, but I managed to kick him, and I started running away. And one of them assaulted me from behind with a sharp object, but I do not know whether it is a kukri as he was attacking me from behind. I ran for about 200 meters and fell down in front of dynamo repairing shop and managed to kick the tin wall of the shop to create a noise. And I also managed to write down the mobile number of my house on the wall of the shops outside with my blood. And I started praying. Then I faintly remembered being lifted in an auto rickshaw and I regained consciousness in the hospital. I do not know those other 3 people who were with the accused on that day, but if I see their face, I'll be able to recognize them. I was firstly treating at Civil Hospital Joy and later at Nickreams. The track cross-examination. The truck I was loading coal and traveling that day is the one I have first hired on that day. I do not know to whom it was belong. The place where the truck was parked that night was about 50 meters from the petrol pump, and the place where I ran for safety being assaulted is about 200 meters from the truck was parked. There was no one at the time when I was assaulted. I could not stop the accused from stabbing me on my stomach and body as he has stabbed my fingers. I had no enmity with the accused person or his family members in Silchar. Kindly note it down, my lord. I have no enmity with the accused person or his family members in Silchar or with his family members in Silchar. Accused is working in Latimbai in a private farm. While I was doing business at Latimbai, the accused used to bring local boys to threaten me and demanded money, saying that I am doing well in business. Next, number 41, my lord. Page number 41. This is IOSRI SI E. Pochan. He stated that I received someone to depose before this court. I am serving in the police department, Government of Meghalaya, and joined service in the year 2007 as sub-inspector. I am presently posted at Umlong Beat House as in charge. In the year 2014, I was posted at Pramar Traffic Cell in charge. My lord, where the incident took place on which day he was in charge at that point of time? Pramar Traffic Cell. This IO. I know of the case as I am the IO of the instant case. On 18/1/2014, a written FIR was received at Pramar Traffic Cell from one Jabir Hussain Borbuya, Labarbuta Village Part 1, PS Katigora, District Kachar. On receipt the FIR, GD entry was made and the case was registered as GD number 340, dated 18/1/2014. This is the first GD has been made, my lord. Dated 340, dated 18/1/2014. I have recorded the statement of the complainant in the meantime. In the meantime, he has recorded the statement of the complainant. I forwarded the FIR to the OC JOIPS to register the case. Accordingly, JOIPS case number 17/1/2014 under section 386, 307, 326, 34 IPC was registered and the case was endorsed to me for investigation. On receiving of the endorsement, I visited the PO, which is located at 8th Mile near petrol pump. On reaching the PO, I have prepared a rough sketch map and also examined 2 witnesses who have been taken the injured victim person, Muhammad Ajmal Ali Borbuya. The name of these 2 witnesses are Lesaras Shila and one of the staff of NRL petrol pump, Sri Shadarnath. The injured person on the same night was shifted to Nagrims as his condition is very serious. Later on, he was discharged from the hospital. In the meantime, as per FIR, one accused person, namely Sri Akhlasuddin Chaudhary, who have been identified by the victim person, himself was arrested and forwarded to judicial custody. During interrogation, he was not cooperating with the investigation nor confessed his involvement in the crime. However, on the day of incident, as per his contact number 9615691904, it is traced out and found that the accused person is present in Meghalaya. Please, it is noted, my lord. However, on the day of incident, as per his contact number, it is traced out and found that the accused person is present in Meghalaya, not in Assam. It is stated here. However, since he did not confess about his co-accused, no one has been arrested after investigation. I found prima facie case against the accused person, so I filed charge sheet by charge sheet number 109/14 dated 28/6/2014 under section 386, 307, 326 IPC based on the statement of the victim and also the medical report of the victim. In the defense, he is stating, my lord, the accused person was arrested on 26/3/2014 based on my requisition to Ladrimbai police to detain the accused person. And later I proceeded to Ladrimbai and take custody of the accused person. So the accused has been surrendered. He has been appeared actually before the PS at Ladrimbai, my lord. And he has been arrested from Ladrimbai PS. It is a fact that nothing was seized in the instant case. He is stating very boastfully, my lord, that it is a fact that nothing was seized in the
The
instant.
victim give a 164 statement.
Yes, it is there, my lord. I'm going to there. Just let me finish, my lord. It is a fact that It is a fact that nothing was seized in the instant case. It is also a fact that on my visit to the PO, there were no bloodstain or evidence available at the PO. Since the matter was reported after 1 week, it is a matter that track which is mentioned in the charge sheet was not seized and no investigation was conducted in respect of the vehicle, as the accused person is not the owner of the vehicle. This is very significant, my lord. He has not neither seized the vehicle nor he has conducted any investigation regarding the persons also. It is also a fact that the driver of the truck was not interrogated. Is stating. It is a fact that the accused person was traced out through his mobile number based on his call details. It is a fact that the accused person is arrested after 2 months of the filing of FIR. He has been arrested after 2 months of the filing of FIR. It is also a fact that during the gap of 2 months, we could not trace the accused person as his mobile number was not available with us. This is also, again, very important, my lord. He is contradicting his own statement because for 2 months, the number was not with him. It is a fact that I filed the charge sheet against the accused person based on the statement of the victim. He is stating that on the statement of the victim, he has filed the charge sheet. It is not a fact that I have not thoroughly investigated the case. There was a suggestion. I have visited the victim at Megrims, but I could not have any conversation with him as his condition was serious. It is a fact that there is no eyewitnesses in the instant case. So now I would like to go to the deposition of 164, my lord, of the victim, 46 to 47. Please, before that, my lord, I want to read this 45, page 45. This is the statement under section 161 of the complainant, my lord. This is very important. My name and particulars is as stated above. I am a laborer by profession. On the 11/1/2014 night, I got information from public. This is the informant, my lord. He is stating that he got the information from public at Pramar. This is Pramar area. This traffic cell is there, you know. Informing me that my brother Ajmal Ali Borbuya, who is working, this is the source of information he received. And in the FIR, he stated a different thing, your lordship. So this is the thing he has stated. And he stated that Ajmal Ali Borbuya, who is working at Ladrimbai, was assaulted by Akhlasuddin Chaudhary at Pramar village. And accordingly, we left for Yalong village civil hospital. And on reaching at Yalong, we found that he is in a very serious condition. We shifted him to Nigrims Hospital, Shillong. Further, my brother narrated to us that Akhlasuddin Chaudhary and his associate demanded money, and which he denied. They attacked him and stabbed his stomach, chest, etc. Intention to murder, and as a result, my brother. Now coming to page 46, my lord. Page number 46, my lord. Can I read, my lord? On 11 January 2014, I loaded coil on truck bearing registration number ML05F2790 at about 1 kilometer inside Sutunga Road. I left the place and reached Mukef village at 9:30 am. The driver wanted to have tea and we stopped for tea. When we were having tea, we met a person who came and asked my driver to have some drinks with him. His driver's friend came and offered him actually to drink with him. My driver started have drinks with the person. So I went to the truck to take a nap. At about 12 noon, I went to tell the driver to move, but they kept on drinking. Till 5 p.m., my lord. At about 5 p.m., we finally left from Mukep. At about 6 p.m. we reached a little ahead NRL petrol pump near 8th mile. The driver and handyman left the track and I was left alone in the track. I saw in my mobile phone that it was about 8 p.m. So I went to have dinner in a shop opposite to NRL petrol pump. After dinner, when I came...
No contradiction.
Pardon, sir?
No contradiction.
Okay. I came back to the track. The driver and handyman was already there in the track. I told them, let us go.
They wanted to go for dinner?
Pardon, sir?
They wanted to go for dinner?
Dinner. Yes.
And he stayed back in the truck?
Yes, my lord.
He was feeling cold, he took out a blanket?
Yes.
And he fell asleep?
Yes.
Later 4 people opened the door?
Yes.
On the driver's side and on the handyman's side?
Yes, my lord.
One of them was the accused, he could not see the others.
Yes.
He was stabbed by the accused and he was chased down. When he got down and ran away, he could not see, but by a sharp object he was injured. The same statement that he had made earlier.
He has stated, but importantly, Your Honor, actually he has not stated before the court, but here he has stated one thing. He has given the clue. Very important thing actually he has stated. In the last line, Your Lordship actually may come. The same person who offered drinks to my driver in Mukab was one of the assailants. Driver and this person who has offered the drinks, they are connected. Here he is stating, my lord. I do not know the names of the other assailants, but will recognize 2 of the assailants apart from Akhlasuddin, if I see them. The left eye of one of the assailants was almost shut. I am almost shut actually. One eye was shut. I am sure the driver was also with the assailants. So he has named actually 2 persons, though not named. One is the driver and one is his friend, Your Lordship. He has stated. And this is statement recorded on 12th day of June, my lord. And at
now,
the end
what are your grounds? Before you come to the judgment, what are your grounds?
my ground is that, Your Lordship, actually this case has not been investigated properly. This is lapse on the part of the IO, because these 2 persons has to come actually to corroborate actually that whether the accused person...
No weapon found?
No weapon found, my lord.
No weapon discovered?
Not discovered, nothing.
Only on the statement of the accused?
Only a solitary witness.
Of the victim?
Yes, victim, my lord.
There is no other...
There is no corroboration, nothing. No.
What does the trial court say?
Trial court said that actually, trial court has lamented actually. I would like to take Your Lordship actually to the para number, para 68. This is running page number 99, please come. My lord. This is one observation over made by the IA. This is para number 68, my lord. And running page number 99. From the evidences of the victim and the IO, it is proven that there is no eyewitness to the incident that took place on the night of 11/4/2014. In such a criminal case, the role of the IO is carrying out a proper and efficient investigation, improving the prosecution story, becomes critical. That the victim has been brutally assaulted and that he has suffered several injuries is proven. That it is now required to prove if the accused person was the person responsible for the crime alleged by the victim. Seen that the IO visited the PO, prepared a rough sketch map and examined PW1 and PW2 and arrested the accused person on 26/3/2014. Para number 70, my lord. IO stated that during interrogation, the accused person was not cooperating with the investigation nor confessed his involvement in the crime, and hence his accomplices were not arrested. It is important here to refer to the statement of the accused under section 164. CRPC inter alia stated that the same person who offered me drinks to my driver in Mukab was one of the assailants. I do not know the name of the other assailants, but will recognize 2 of the assailants apart from Akhlasuddin. If I see them. The left eye of one of the assailants was almost shut. I am sure the driver was also with the assailant. Even if the statement of the victim under section 161 CRPC is perused, 161 of the victim statement, it is clearly evident that he has provided similar lead to the IO. It is nowhere brought forth by the IO that he has made an attempt to identify and seize the track which could have provided useful evidences. Though the victim has mentioned the registration number of the track in both the statements under section 161 CRPC and 164 CRPC, the IO did not take appropriate and necessary action. In such circumstances, it is not seen as to why the IO prepared to sit idle on such evidences as not proceed to apprehend and examine the other persons as alleged by the victim to find out if they have any role in the crime. But the IO preferred to opt for an easy way out to depose that the accused person was not cooperating during investigation and hence the other persons could not be arrested. What is the reason? Your Lordship can understand what he has stated, the IO. IO did not, para number 75, IO did not find any bloodstain or evidence available at the PO since the matter was reported after 1 week. The evidence of the victim gave me a picture that he was stabbed inside the track. When the track itself was not seized, then it is no wonder that bloodstain were not found. This is the mandatory. The IO was very much actually in a duty bound to seize this vehicle, my lord, and moreover to be interrogated this driver, and because after the incident, driver and handyman nowhere there in the picture, your lordship. In the para number 72, again the Lane trial court is observed. IO has stated in his cross that he did not seize the track and no investigation was conducted in respect of the vehicle, as the accused person is not the owner of the vehicle. The question that needs to be asked is, how does the ownership of the vehicle matters? It is clearly evident from the FIR deposition of the victim and his statement under section 164 CRPC that the main part of the incident happened inside the track, but the IO did not take steps to seize and investigate the same. As per the IO, on the day of incident, the contact number 9696 of the accused person was traced and found that the accused person is present in Meghalaya, not in Assam. In his cross, the IO stated that accused person was traced out through his mobile number based on his call details, and the arrest was made after 2 months of filing of the FIR. Despite the above claim, the IO has not produced any material or document like call records to prove the same. From the evidence at hand, the IO could not prove the location of the accused person at the time of the incident at the PO. So these two things actually very clear, my lord, actually. This Lane trial court also.
You read paragraph?
Pardon?
Just now you read paragraph 72.
This is 73, 68 to 73, my lord.
Yes. Just a second.
And in the page number 102, in view of the...
Just a second. Just give us 1 minute.
Okay.
Page number?
Page number 102, my lord.
102.
Yes. Paragraph number 76.
Now, two things, sir.
Pardon?
One is that no suggestion was put
Yes.
to the victim about motive.
Yes.
Why would the victim falsely implicate the accused?
Yes.
No suggestion was put. Number two, and most importantly, in response to 313,
Yes, my lord.
he said that I was not at Ladrimbai on that day. I had gone to Assam. I came back to Ladrimbai only on 13th of January. So this was not a case of I don't know.
Yes, my lord.
He makes out a positive case that I was not in Ladrimbai on the date of the incident.
Yes, my lord.
Later, in response to number 4 question, he says, I came back to Ladrimbai on 13th.
After the day of incident, actually.
IO has indicated that on the basis of phone call details, he was found to be in Meghalaya on the date of the incident and not anywhere else. Now, in such state, when no motive is attributed to the victim,
Yes, my lord.
number one, the FIR maker is not cross-examined.
Yes.
FIR maker says that for a short while the oxygen mask was removed and brother named accused. He was not cross-examined. So therefore that is accepted, that brother named accused. Brother gives a full description of the incident. It tallies with the evidence of Shella and that Shan Sardar. Shella is the auto driver and Shan Sardar is the petrol pump attendant. In such state, you ought to have demonstrated that you were not in Assam or in Meghalaya at the time of the incident, on the date of the incident, or that you came back on 13th. These are two positive statements. You did not attempt to prove it. So how is the trial court wrong?
No, I'm not saying trial court is wrong, my lord.
There are several things that the trial court has said,
Many
and
things.
probably rightly.
Yes, if I say, my lord, actually trial court has discussed actually in detail everything.
Everything.
Except-
But why will the trial court, in the absence of your making out any motive
Yes, my lord.
against him,
Yes, my lord.
against the victim, why will the trial court disbelieve what the victim has said?
Yeah, solitary witness, actually court has believed actually his statement. That is actually court part is okay, my lord.
Yes.
But thing is that when a criminal case is there, my lord, actually, your lordship is very much aware that actually it has to be proved beyond reasonable doubt. And whereas the investigation is incomplete, I can say actually from my side that investigation is incomplete.
Maybe. Just because the investigation is incomplete does not mean that you have to wish away the ocular evidence which is available.
Which is available, right, my lord. My lord, only one thing I want to actually...
Convicted under 307 and 326.
326, my lord.
Not under 386.
No, 386. This is not actually proven from the statement of the same victim.
It's not proven. There is no, from the statement there is no 386 made out.
386, it is not.
386 is not made out, but the victim has said earlier when he was in Ladrimbai, he would come to demand money on the ground that you are doing well in business. That previous is there.
Enmity, you may say.
Previous, yes, enmity and that he is an extortionist is there. But no allegation of extortion at the time of the incident.
But the previous one also not been actually proved. Nothing he has actually stated, no evidence has been given.
Nothing.
Yes, my lord. But one thing I would like to actually mention here, my lord.
Yes.
That is in my appeal also I have stated, whatever actually has been done by the defense counsel in the trial court, this is a very sorrow state of affair, my lord, actually, because one complainant has not been actually, he has declined to actually cross-examine the complainant.
Exactly.
Yes.
So
Another thing is that
we pointed it out to you,
yes,
that the complainant said,
yes,
that short while mask was taken, he named the accused.
So
no cross-examination.
yes, my lord. So I want to actually just draw the attention of this honorable court, my lord, whether whatever has been stated actually, how he has stated, the complainant, that for a short while actually the mask has been removed. And he has stated a number of things. If I read also actually from beginning to end, it will take at least 2-3 minutes. So whether it is a short while actually, whatever has been described.
That short while in the life of a human being, short while can be a few days. In the life of the country, the short while can be a few decades.
Yes.
In the life of the universe, the short while can be few 100 million years.
No, my question is that, my submission is that, my lord, actually, whether is it possible actually, whatever stated actually.
Anything else that you wanted to?
Anything else?
We have gone, the trial court has reasonably dealt with the matter.
Lordship, if permits, actually, in my appeal also I have mentioned actually,
Yes.
regarding this one judgment of the court is there actually, the Silchar court. I would like to supply this copies. Because he has very clearly stated, this victim, that no enmity, everywhere he has stated, no enmity is there with the accused person. But rather it is 10 years actually, one case has been actually running there. And this accused person has been actually acquitted, along with 7 others in that case.
How does that matter?
That matter actually relating to that actually, this is a fabricated.
That has nothing to do with this.
This is against a class of the same victim has filed, my lord, this case. And whereas stating in his 160.
This case is filed when?
This is in 2010 case, my lord. This is against Akhlasuddin is the main first accused.
Oh, Jasbir Hussain Chaudhary.
Yeah, Jabir Hussain Chaudhary.
He is abated. Jabir is who?
Jabir is the brother of this this victim.
He is the FIR maker.
Yes, here they are.
Over here, Jabir is the FIR maker.
FIR maker, my lord.
Why is it abated?
Pardon, my?
Have you died?
No.
Abated?
Nothing else, my lord. In this case, actually, my accused and along with 7 others actually got acquitted in that case. Both the brother, PW3 and PW4 are involved in this case. They have filed this case against the accused and others.
But you have not cited this before the trial court.
That is, I mentioned in my appeal that if this case has been cited, actually, my lord, the court's view would have been different.
Maybe, could have been.
Could have been different. So this is actually extended trial court. I humbly submit, my lord, actually. This case has to be actually considered and the evidence has to be examined properly.
Let us see.
That is the thing. This court has the power actually to examine all the evidences, my lord. Because
And this is beyond reasonable doubt, not honorable acquittal.
Which one here?
Over here is beyond reasonable doubt, hostile, witness have turned hostile.
Yes, ma'am.
This is not honorable acquittal.
Even then, my lord, actually, this is, court has, the,
Anything else?
no, nothing else more than that, actually. This is the thing.
Thank you. You've done well.
And another thing is that, my lord, actually, I would submit one reference only if this honorable court permits it.
Definitely.
This is one case law I have cited, actually. This is
Silchar case, and the judgment that you want to cite is?
this is actually, my lord, one is actually Badri versus State of Rajasthan, SCC 1976, my lord. SCC 1976.
No, give us the proper reference.
This is Badri versus State of Rajasthan.
Forget the name, give us the reference.
Reference actually, this is actually regarding criminal investigation.
Reference, what is the citation?
Citation is this, my lord. This is SCC 1976, volume 1, page number 442 to 449.
1976,
volume 1,
SCC, page?
Page number 442 to 449.
442.
449. 442 to 442.
Very good. You don't know how to cite a judgment.
Yes. Another one, second one is that AIR 2003, my lord.
AIR 2003?
SC 854, my lord.
8?
854.
854?
Yes, my lord.
Very good. Give us
And another one is that Karan Singh versus State of Haryana.
reference.
Reference SCC 2013, volume 12, page number 529.
A lawyer, you don't know how to cite.
Yes.
It's 2013, 12 SCC.
Yes, sir. 12 SCC, yes, ma'am.
Page
529.
5 to
9.
9. Yes. Show us. Do you have copies, photocopies?
2 cases I have.
Yes. Give us the 2 cases that you have. The other case that you don't have, we'll get the book. Keep it. Yes. Show us the first one. What do you want to rely on? Which part?
This point is this is a sole witness not absolutely reliable.
Yes.
My lord, actually, this is page number regarding 15. Para number 15, my lord.
Paragraph 15.
15, yes, ma'am.
Very well. The next one?
Para number 15 and 19 in this case.
19.
15 and 19.
15 and 19.
Yes, my lord.
19 is? So
Can I read this?
next one is
Next one.
AIR 2003.
Yes, ma'am. This is also relevant para is para 10 and 15, my lord.
Relevant paragraph is 10 and 15.
10 and 15, my lord.
10 and 15 you said.
Yes, my lord.
Paragraphs 10 and 15.
15, yes, my lord.
And the last judgment?
And the last one is, my lord.
2013-12 SCC?
Yes, this is 2013-12 SCC 529, my lord. Page number 529. Paragraph 13, 15,
13, 15,
17,
and
21, 22, and 25.
21, 22, and
25.
25.
Yes.
All the paragraphs that you cite are against you.
Which paragraph, my lord?
All of them.
No, this is, I'm talking about this proper investigation, my lord.
Yes, proper investigation.
So it is to be accused right also is there actually, my lord. The IO has to do the proper investigation because for that actually I should not be prejudiced. That is my reason.
No, that is not the thing. 23, 20.
If the IO would have, my submission is that, your lordship, if the IO would have actually done the proper investigation, I would not have been in the bar actually, beside the bar.
Thank you. The only ground urged on behalf of the appellant in this case is that there was no witness to the incident, and it was only the unilateral statement of the victim on which the appellant has been convicted. Full stop. The incident was of January 11, 2014, the complaint was filed with the Jawai police station on January 18, 2014 by a brother of the victim, full stop. Such brother claimed that he had been informed by the victim brother that it was the appellant who had grievously injured the victim in an incident that took place near a petrol pump at NH 44 around the 8th mile close to Ladrimbai. Full stop. As to the delay in lodging the first information report, the de facto complainant indicated that since the victim was struggling for his life and continued to be serious, the de facto complainant had not found it convenient to lodge the complaint earlier, and the complaint was lodged immediately upon the victim first taking some food after suffering the injuries. Full stop. Paragraph. A statement of the victim was recorded under section 164 of the code by a judicial magistrate. In course of such statement, which was substantially corroborated in course of the victim's deposition at the trial, the victim indicated the relevant truck number wherein he suffered his injuries, full stop. The number of the vehicle matched with the registration number disclosed by the de facto complainant in the FIR. Paragraph. According to the victim, his truck was loaded with coal on the morning of January 11, 2014, but the driver made some excuse to leave the truck and return much later. It was in the late afternoon that the driver returned, and after proceeding a distance, the driver warned the victim that there was checking of vehicles going on at the nearby checkpost and the truck ought to wait before proceeding any further. It is obvious that the truck in this case was ferrying illegally mined coal, as Ladrimbai is famous for such illegal cottage industry in the state, despite orders of the National Green Tribunal and the Supreme Court prohibiting any form of coal mining otherwise than in accordance with the provisions of the Mines and Minerals Development Act 1957, I think. Development and Regulation, MMDR Act. Full stop. Paragraph. The victim went on to say that since the driver and the helper did not return for quite some time, the victim finished his dinner and after returning to the truck found that the helper and driver had arrived. Full stop. It was then the turn of the driver and helper to go for dinner, and the victim claimed that since it was cold, he pulled a blanket over himself and fell asleep inside the truck. According to the victim, he was awoken upon the two doors being suddenly opened and two persons each standing on either side of the truck. Full stop. The victim claimed that he could not recognize the three other persons, but clearly recognized the appellant herein, who had climbed onto the truck and demanded money. Who had climbed onto the truck and had threatened to assault and, thereafter assaulted the victim. The victim claimed that he kicked at the other persons and held them at bay, but he could not avoid the cookery of the appellant herein and felt that his intestines had come out. Full stop. In course of the fight, in course of the tussle, the victim fell out of the truck and ran away, according to him, to a distance of approximately 200 meters with one or more assailants in chase and striking him with a sharp weapon that he could not, and striking him on the back with a sharp weapon that he could not see. Full stop. Paragraph. The victim went on to describe that he found a tin door which he kicked to create noise, to alert people, if they were around, and he wrote down a phone number with his blood for anyone to inform his nearest relatives. Full stop. The victim claimed that he passed out but had a faint recollection of being ferried in an auto rickshaw to a hospital. Full stop. He then described that he was ultimately taken to the Negrams in Shillong, where, after a prolonged period, he was discharged. Full stop. Paragraph. The auto rickshaw driver who had driven the victim to the Jawai hospital was examined as PW1 at the trial. Full stop. He clearly stated that he did not witness the incident and was awoken by a helper who worked in the nearby petrol pump, who informed him that a person had been injured and had to be taken to the hospital. Full stop. Paragraph. The relevant attendant at the petrol pump deposed as PW2 and corroborated what PW1 said. Full stop. There may have been a third person who accompanied PW1 and PW2 along with the victim to the Jawai hospital. Full stop. Paragraph. The third witness to be examined by the prosecution at the trial was the FIR maker. Full stop. He substantially repeated what he had indicated in the FIR and added that for a short while, while the patient was being transferred from Jawai hospital to Negrams in the early morning of January 12, 2014, the oxygen mask fastened on the patient was taken off for a short while, and the victim brother named the appellant herein as the principal assailant. Full stop. It must be noted in such context, that the defense declined to cross-examine the FIR maker at the trial. Paragraph. The victim took the witness box as PW4, followed by the investigating officer. Full stop. A medical attendant, a medical practitioner, pursuing his postgraduate studies and then posted at Negrams, was examined as PW6 and confirmed the stab injuries suffered by the victim. Full stop. In course of the detailed discussion of the matter by the trial court, the trial court found that the investigation was completely unsatisfactory and no effective measures were taken. You can take your seat, sir. And no effective measures were taken by the investigating officer to ascertain the veracity of the incident or to obtain the weapons that may have been used, or even to try and get the associates of the appellant or the other alleged assailants that the victim had somewhat described in course of his statement given to the investigating agency and the one recorded before a judicial magistrate. Full stop. In particular, the trial court came to the conclusion that the investigation conducted was extremely poor and observed as such at paragraph 76 of the impugned judgment of, what is the date of the judgment?
17/3/2022.
17/3/2022.
2022.
Impugned judgment dated March 17, 2022. At paragraph 74 of the judgment, the trial court lamented that not only was no weapon seized, there may not have even been any meaningful attempt in such regard. Full stop. At paragraph 73 of the judgment, the trial court observed that there was no attempt by the investigating officer to even establish the presence of the appellant at the place of occurrence. Full stop. Elsewhere in the judgment, the trial court noticed that no attempt was made to seize the relevant vehicle or to obtain any bloodstained material therefrom, or even collect the earth from the bloodstained place of occurrence. Full stop. Paragraph. The appellant was arrested some 2 months or so after the incident, and the investigating officer indicated that such arrest was made on the basis of the appellant's calls from his mobile number being traced. Full stop. It also appears that it took time for the investigating officer to obtain the mobile number of the appellant herein. Paragraph. According to the appellant, it was unwise of the trial court to merely rely on the uncorroborated statement of the victim to convict the appellant. Full stop. The appellant asserts that since it is the admitted position that there was no witness to the incident, comma, some corroborative material, comma, whether it be any offending weapon or any bloodstained clothes or any other like material should have been presented by the prosecution for the appellant herein to be linked to the incident that obviously took place on the night of January 11, 2014. Full stop. Despite the trial court noticing the complete lack of endeavor or enterprise in the investigation, comma, the failure to discover the offending weapon or present any other material evidence pertaining to the incident, comma, the trial court, it was found that merely because the offending weapon could not be found or there may not have been any witness to the incident, comma, would not result in the case built by the prosecution against the appellant altogether failing. Full stop. There are several features which stand out. Full stop. First, comma, the defense made no attempt to subscribe or allege any motive, not to subscribe, attribute or allege any motive to the victim for the victim naming the appellant herein as the principal assailant. Full stop. Indeed, comma, in course of the victim's testimony or his statement recorded under section 164 of the code, comma, the victim indicated that he was familiar with the appellant herein as both operated in Ladrimbai and the appellant had apparently previously demanded extortion money from the victim in Ladrimbai, which the victim had declined. Full stop. Paragraph. Apropos the victim's assertion of previous enmity with the appellant herein, comma, the appellant relies on a judgment rendered by the Judicial Magistrate First Class in Silchar on November 13, 2019, when an allegation of extortion was levelled against the appellant herein by the victim and the FIR maker brother of the victim. Full stop. However, comma, it does not appear that such judgment had been placed before the trial court. Full stop. The appellant, comma, the appellant submits that this was a relevant fact that ought to have been brought to the notice of the trial court, and merely because advocate representing the appellant had failed to do so, comma, should not be counted against the appellant, as the judgment, as the relevant judgment would demonstrate a motive on the part of the victim to name the appellant herein, and would take a lot of sheen of the victim's allegation against the appellant. Full stop. Paragraph. Even if the fact that the Silchar judgment ought to have been placed before the trial court is disregarded, and such judgment is taken into consideration in the present case, comma, it cannot be lost sight of that motive is a question of fact, and such fact was not asserted by the appellant herein before the trial court. Full stop. Even if some suggestions, even if some credible suggestions had been put by the appellant herein to either the victim or the FIR maker in course of the trial to suggest that such persons had some ill motive against the appellant, comma, the benefit of the doubt may have been extended to the appellant if the appellant had been honorably acquitted by the Silchar court. Full stop. Paragraph. However, comma, apart from the fact that no attempt was made by the appellant to attribute any motive on the part of the victim or the FIR maker, comma, it is also evident that the Silchar case fell through because one or more of the witnesses turned hostile, and the prosecution could not prove the case against the appellant herein beyond reasonable doubt. Full stop. As is now judicially acknowledged, comma, there is a distinction between an honorable acquittal of an accused and the acquittal of an accused because of the prosecution failing to discharge the high burden of proving the commission of the offence beyond reasonable doubt. Full stop. Indeed, comma, contrary to what the appellant suggests, comma, the Silchar judgment demonstrates that the appellant herein may have been given to indulging in extortion, and also corroborates the victim's statement that the appellant had previously demanded money from the victim in Ladrimbai, which the victim had declined to part with, had refused to part with. Full stop. Paragraph. More importantly, comma, upon the defense failing to cross-examine the FIR maker, despite the FIR maker's assertion that the victim brother had named the appellant herein as the principal assailant, comma, the defense virtually accepted the FIR maker's version of things. Full stop. In addition, comma, upon the appellant being questioned by the trial court, being examined by the trial court under section 313 of the code, upon the testimonies of the witnesses being summarized and put to the appellant, comma, the appellant made two important statements. Full stop. First, comma, the appellant claimed that he was not in Ladrimbai or in Assam on the day of the occurrence. Full stop. Secondly, comma, the appellant asserted in response to a later question that the appellant only returned to Ladrimbai on January 13, 2014. Full stop. Paragraph. It is elementary that it is not necessary for an accused to make any positive assertion in course of his examination under section 313 of the code. Full stop. However, comma, when an accused makes a positive assertion in course of his examination and which seeks to detract from the case made out by the prosecution, comma, it is incumbent on the accused to prove such assertion or prove such assertion. Full stop. The mere assertion without attempting to prove the same would be held against the accused rather than permit the accused to pick a hole in the prosecution case. Full stop. Paragraph. For the reasons aforesaid, comma, the trial court found enough material before it, comma, particularly the eminently credible statement of the victim, comma, to find that the appellant was involved in grievously hurting the victim. Full stop. There is no doubt that the injuries inflicted by the appellant were so serious as to almost bring his intestines out. Full stop. The serious condition of the victim was is evidenced by the Jowai hospital immediately referring the appellant, the victim, to the super specialty unit in Negrams in Shillong. Full stop. The FIR maker's evidence is clear that the victim spent more than 15 days in the intensive care unit at Negrams. Full stop. Indeed, comma, even in the FIR, comma, the de facto complainant indicated that the victim's condition was so serious that the complainant could not leave him earlier to make the complaint before January 18, 2014, full stop. Considering the circumstances and the nature of the injury, comma, it may have led to the death of the victim unless it may have led to the death of the victim, semicolon, but, comma, as Providence would have, comma, there were the good Samaritans in the petrol pump attendant and the auto rickshaw driver who ferried him to the Jawai hospital, from where he was sent to Negrams and recovered after a prolonged period. Full stop. Paragraph. In the light of the conviction of the appellant herein and the nature of the injuries inflicted by the appellant on the victim, comma, the appropriate sentence has been awarded and it requires no correction. Full stop. Paragraph. Criminal appeal number 28 of 2022 is dismissed by upholding the judgment and sentence passed by the trial court on March 17, 2022. Full stop. Let an authenticated copy of this judgment and order be immediately made available to the appellant free of cost. Thank you. Three things. In support of the appellant's case, comma, 3 judgments have been placed, colon, 1976 1 SCC 442, put the cause title, semicolon, AIR 2003 SC 854, put the cause title, semicolon, and, comma, 2013 12 SCC 529, put the cause title, full stop. All 3 cases involved murder charges against the appellants before the Supreme Court, full stop. In the first case of the cause title, 1976 cause title, the conviction was based on the evidence of a solitary witness, full stop. The court found that such witness had indicated that when gunshots were fired, he was frightened, he claimed that he was frightened and ran away from the place of occurrence, full stop. In such circumstances, comma, the Supreme Court disbelieved such witnesses' further statement to the effect that he had seen the appellant shoot the victim, full stop. Surely, comma, if the witness claimed that he had run away at the first hearing of gunshots, comma, it was difficult to believe such witness when he said that a later gunshot by a particular person struck a particular victim, full stop. Paragraph. As far as the 2003 case, that cause title, comma, PW9, comma, Mannu, comma, was the only witness, full stop. The Supreme Court found that the initial statement made by such witness under section 161 of the code was embellished by him to a great extent in course of the trial, full stop. Indeed, comma, the Supreme Court found that the relevant witness modulated his version of things to suit the subsequent opinion rendered by a medical practitioner, full stop. It was in such circumstances that the conviction of the appellant, based on the rather doubtful evidence of the sole witness, was annulled, full stop. In the third case, comma, the cause title, the appellant's conviction was, comma, indeed, comma, upheld by the Supreme Court, full stop. The court found that the investigation in this case was tardy and it had been observed as such by the trial court, full stop. However, comma, the Supreme Court held that merely because the investigation was tardy would not lead to the accused being let off if there was credible material against the accused available in the evidence, full stop. The principle enunciated by the Supreme Court in this case does not further the cause of the present appellant, full stop. Then write the last three concluding paragraphs from the judgment.
Yes.
Yes, but he has not been convicted under 386. He's been convicted only under. Please keep this inside that.
All right. ये सब एडजर्न हो गया था ना? हाँ, ये कैसे हो गया?